pointed that out, Paul.
Yeah, because I use that to catch up when I leave early. But anyway, I don't know how many views the rabbi gets on that.
I don't get a lot of views because it's not
publicly advertised.
Right, yeah. And it's raw, so. Okay, so I hope now it's recording.
Thank you.
Thank you.
So if I ask a question that was discussed yesterday, later in the shir, that's why.
That's impressive that you come on. Nothing's responding. Go. All right. So we're finally up and running. Okay. So we talked about the difference between an Arev Sam and an Arev Kablan. Let us go on. She'ela. Arev Hayotze la'acha chitum shtarot. A guarantor who steps forward after the documents have been signed. Dahainu la'achar shechatmu ha'idim b'shtar katav ha'arev va'ani arev. So meaning that below the witnesses' signatures on the loan documents, he writes, I am a guarantor. V'nikar shiksav yadahu. And all you know is that you can recognize his handwriting. Hayim oto shekata va'ani arev mishtabet lamalva. Has that enough to indebt himself as a guarantor?
So saying he doesn't affix his name, he just writes those words.
Yeah, he just writes, and I am the guarantor. Oh, ein kan din arev lachar shechatmu ha'idim al shtar halva. The real question is not so much his signature. The real question is the fact that he wrote those words after the witnesses signed the documents. So it's below their signature. So you could argue that he doesn't mean for it to be taken seriously. So he writes, and this is an important issue as far as, when we learned in Imre Yaakov towards the end, the laws of documents, the laws of legal documents, anything that's written usually underneath the signatures of the witnesses is not legally binding, right? So what does that count as far as a loan document? So tshuva misha kasa va'ani arev v'nikar shezek ksav yado la'achar shechatmu ha'idim o sheha'edim me'idim alav shezek ksav yad ha'arev. So if he puts it beneath the witnesses' signatures or the witnesses testify that is his handwriting, yesh omrim shemishtabed below kinyan likvos mimenu bnei chorin. Some say that that's enough to make him a guarantor, such that if the debtor defaults on the loan, you could seize his unencumbered assets. V'yesh omrim she'eno mishtabed ela b'kinyan, and others say no, that he would have to make a kinyan in that case, because making a kinyan obviates the need for a shtar. In other words, this second opinion holds that writing something after the signatures is meaningless. Ula Rambam afilu arev hayotze kodem chitum shtarot tzorach kinyan kol shenichnas ha'arev la'achar matan ma'ot. The Rambam paskins even more than that. Even if the guy's name is before the witnesses' signatures, if the money has already been exchanged between the lender and the borrower has the money, then it's not enough for him to just write, I'm a guarantor, even if it's before the witness's signatures. Because remember, we said that it all depends on the reliance of the creditor. If the creditor's reliance is on the guarantor, so then he's a guarantor. But if his reliance is not upon the guarantor, because he gave the money before the guarantor ever stepped forward, so then you can't hold him liable. That's the Rambam Shita, even if a person puts it in writing that he's a guarantor. So we have different opinions about this. Next, let us continue. She'ela, Misha Amar L'malve Hilveu Leploni Ve'olai. So a person says to a lender, he says, lend him the money and it's on me. Now, it's on me. What is that? It could be open to interpretation. What does it mean it's on me?
It means he's going to pay it back.
It could be,
as opposed to I'm the guarantor.
well, it could be I'm going to pay it back. It could be I'm the guarantor, or it could be it's on me for you to do me a favor, but I'm not acting as I'm not taking any responsibility.
Yeah.
It's not there.
That's a wide range of
Yeah.
what it could be.
Yeah.
Oh, sha'amar ein chatzarich lidog v'hakeren betucha. Or let's say he says to the lender, lend him the money, you have nothing to worry about. The principal is secure. Now, he didn't say that he's securing the principal.
We say the guy's good for it.
No, but we had this before where if you say to the lender, the person's in good faith, I trust him, I've had good dealings with him, he's okay, then you effectively have acted.
Right, because an endorsement is enough. So Osha Amar ein chatzorach lidog milahalvos leploni ani omed kan. Or let's say he says you don't have to worry about giving him a loan. I'm here. That's all he says. I'm here.
I've got your back.
Yeah, like Obama said, I got your back.
We have okay.
And I could shoot you in it, yes.
Haim ba'amirot elu shamar lamal v'nechshav arev u'mishtavid lamal v'oin alav dinar. So is that enough to make you a guarantor or not? So let's open up. I sent you this next packet, didn't I, Barry?
You sent them all out.
So let's open up the next packet. My computer cooperates.
You have to specify that you want to be guarantor, otherwise it's too vague and say, okay, don't worry, it's on me, or I hold your back, but that doesn't mean you're on paper, maybe you are, then used to be good, but now it's not so anymore. Things change financially and
Well, if you're not clear on what you say, then it becomes too exact. There are lots of different.
I presume we're assuming witnesses when he says it as well. Because otherwise. He just says something.
Right, well, on the previous one, when we spoke about the signature of the guarantor being above or below the witness signature.
Yeah. Mhm.
So that sort of implies that the guarantor needs to be present at the time that the transaction is being done. But, I mean, if he has to sign it and the witness is that he has to see that.
Well, we didn't say that he had to sign.
No, but there was a machloek as to whether the signature, whether it was done at the time of the loan or after the loan.
Yeah.
Or whatever.
Yeah.
So we learned previously about you could appoint
A shaliach.
A shaliach.
Yeah.
And
So
therefore that's done.
we're not saying that this is the only way to become a guarantor. We said if indeed the person's name is on the loan documents, there are times when it can be legally binding, and sometimes, according to some, it is legally binding, and according to others, it's not. Now, whenever you have a machlokes, remember in cases like this, then the person who's the alleged guarantor could always say, I paskin like the other guy, right? And he can absolve himself from having to pay.
Fingers crossed.
Right. Okay, so the response is Teshuva kol halashanos halalu sheizkarnu le'el ba'amiras ploni lamalva ein alav chiyuv shel arev ve'eino mishtabi lamalva. That's shocking. He says these are not enough to make yourself a guarantor because they're too vague. Now what about the fact that we learned before, that as long as the creditor's reliance is on the guarantor,
Yes.
then he's on the hook. So he's quoting from the Mabit, who's an early Acharon, who says that Ein alav din shibud malva shari ef shalomer shekavanasa haisa halvehu ve'olai shelo tafsid shu yifra lecha. Because the guarantor could always say that I didn't make myself into a guarantor, but when I said it's olai, it's on me, right? I know you won't lose money because he'll pay you back. Oh, olai litroch ba'adcha v'ligvos mehalova bishvilcha. Or I'll do my best to try and get him to pay you back. Oh, alai lahavi enu shelo yivrach. Or it's on me to make sure that I can bring him to you and he won't leave town. In other words, maybe that's what he meant, that I'll make sure that he doesn't leave town. Now, making sure that someone doesn't leave town is very different from making sure that he has enough money to pay back the loan.
Even more different than I'll pay if he doesn't.
Yeah. Va'ayin b'shut avkat rochel shemistapek b'lashon zeh. But the sefer of Avkat Rochel is not so clear. So he basically says there has to be enough of a clarity of language that it's clear that the guy is essentially, even though we learned before that if I call you up and I say, is this a reliable person to lend money to? And if you tell me, yes, you can rely on him, he'll pay you back, then that in itself is making yourself into a guarantor. So
Sometimes the guy was solid before and he always paid back his wages, and then all of a sudden he fell on hard times and suddenly went on.
Before those, the language
Right.
you have to use.
So
Right.
you're not guaranteed. We're just saying he has I can vouch that he's been an Erlich Yid, upstanding person, and now things have.
Right, but we all-
Come to me, the one where I
That's what I'm
signed for the,
saying. So the guy
so the
signed for you?
co-signer, he was fine and everything before, now, I don't know what happened. No, and then I was on the hook.
it was your fault, Ron.
No, you're not putting your name on.
Well, but we did learn before that a guy could take you to Basin if he says the whole reason why I lent the guy the money was because you told me that he's good for it. So you have to say, right, and the way that you expressed it, Moish, is you have to say, I've had only good experiences with this guy. And if that's truthful, then you're not acting as a guarantor. I'm not saying that you can rest assured that you'll get your money back. You have to say, this is my experience. In my experience, he's been very reliable. But as long as you're not forecasting what's going to happen in the future, then you can't be held liable.
I think even more clear, you just say, I'm not a guarantor, but this is what I can tell you.
Yeah.
And then it's clear you're not a guarantor.
And
You just say, I'm not a
and
guarantor.
therefore it comes down to the language you use this when you're given the reference.
Yeah.
But you still, if you say I'm not a guarantor, but you really recommend to do it, you are involved.
No,
That's how I said, but if you
Yeah.
say, this is my experience, it limits to what is your transaction, are good, so it's fine.
I mean, would you be hold to be a guarantor if you say I'm not a guarantor?
It would seem that way, but if the second statement that you make makes you sound like a guarantor, right? Counteract.
You could still obviate the disclaimer that I'm not a guarantor. I mean, I would hope that if you say I'm not a guarantor, then no matter what you say afterwards, you're not.
Actually, though, there's many contracts where the parties say, we're not, this is not an employer-employee relationship. Then they go to court, court says, I don't care what you say, or Revenue
Really?
Canada says, I don't care if you don't say you're an employee, you are in fact employed, because you
Really?
meet the test.
Yeah.
Right.
So self-characterization is
It
no.
quacks, if it quacks like a duck, yeah. Yeah.
And then you get the bill, right?
Yeah.
No, the secular case where a lawyer was sued, the lawyer was sued because he recommended to this big company to invest with this guy, and this guy was fraudulent.
Yeah.
And the money disappeared, and they came back and they sued the guy who stole the money and the lawyer who recommended it to use him, and they didn't win. They
Well,
will not win.
so a lot of times, like we did see this distinction. If you can verify that the lawyer had knowledge that the guy was a shyster, then you could win. But in halacha, but if the guy innocently says, like in Ron's case, he was perfectly fine. He had a good track record up until that time, and so then the lawyer wouldn't be held liable because he was giving an honest assessment based on what the guy's track record up until then was.
There are many cases also with third-party auditors. Let's say there's a company you invest in and all this, and they hire auditors, the KPMG or whatever. The auditors miss the fact that this company is really not a good investment. They negligently perform their audit. The third-party investors that lose often sue the auditing company.
That's-
say,
Yeah, but that's why they-
because
That's
we
why
didn't
I'm
invest-
leaving now,
yeah,
because now you're getting into my.
They were negligent, in their assessment of the, whether or not.
You relied on, their report or whatever.
Right.
Okay, next. She'ela. Ha'im kedei liot arev al halva tzarich sheyeh sikum hachov katzuv v'rak az mishtabed lamalva. So does the guarantor have to know how much the loan is for in order for him to be indebted as a guarantor? Or al kol sikum shekibel alav arivut ha'arev mishtabed? Or do we say if the guy says, don't worry, I'll guarantee the loan, even if he doesn't know the amount? Or could he come back and say, you borrowed how much? Right? And then he says, well, I never meant to be, a guarantor on that amount. So can a person say that after the fact, thinking that it was going to be a small loan and it turns out to be a large loan? So this is an interesting shaila. And he writes, Yesh misha omer she'ein ha'arev mishtabed ela keshekatzav et sikum hacho v'zohu das Rambam. He says the Rambam is of the opinion that you can only be seriously taken as a guarantor if you know the amount that is being lent. Sha'al davar she'eno katzuv ein ha'arev chayv klum. Because if he just knows that there's a loan being extended, but he doesn't know how much it's for, he's not serious when he says he'll act as the guarantor. Ba'atam keben sheni yodea hadavar sheshibed atzmo bo lo samcha daita v'lo shibed atzmo. And the reason is because since he doesn't know how much the amount was for, he wasn't being serious. He wasn't seriously indebting himself. However, that's not the majority opinion. The majority opinion is that as long as he said, I am the guarantor on this loan, even if he doesn't know the amount, he does obligate himself. And that's actually the opinion of the Beit Yosef. Remember, he's a Sephardi posek. He says that the Beit Yosef quotes the Rambam's opinion, but then he says, but all who came after the Rambam disagree with him and are of the opinion that a person does obligate himself.
So he originally was under the impression that it was $100,000 loan, and he finds out 6 months later we didn't pay, it was a $5 million. According to them, that you have to claim to pay.
Yeah. Why? No. Well, it's not like. On what basis did he think that it was $100,000? He thought maybe because he thought that he was under one impression, but if there was no indication about the dollar amount, and he said, "Don't worry about it. I know you're good for it. I'll cover you if you default." If you gave every assurance to both the lender and the borrower that you would be a guarantor, then you're a guarantor.
It's a little bit of a slippery slope. If I phone you up asking for what's your thoughts if I lend some money to so and so down the road who lives next door to you?
Yeah.
You know him quite well, so you say, "Oh, look, he'd be a good guy. I would do it, right?" You don't know how much I'm doing, how much, I haven't told you how much money I'm about to lend.
That's correct.
But you're now on the hook as the guarantor because you told me you would do it. So how can you have a both?
One second. I said I would lend him money. Is that what I said?
You said to me, I would do it, all right? which is along the lines of what we studied just before.
Yeah.
So I've asked you for a
So,
reference, you basically set yourself up.
Yeah,
as a
so let's,
guarantor,
so,
but we
right.
haven't- But we haven't covered the amount of money.
So let's assume that that does make you a guarantor, because remember, when with ambiguous language, there's a machlokas whether you become a guarantor or not.
Okay.
But let's assume you become a guarantor. Why would I say I would do it if I don't know how much money we're talking
Because
about?
when you were talking to me, you were talking as a reference.
I know,
So
so
what I'm trying to say is this Shiloh that we just.
here,
gone
let me,
through, sort of-
great word reference. Let's say someone calls me up about Doug. And they ask me,
I wouldn't do it.
Mr. Ross has applied for a job at our company. Can you act as a reference for him? And I know that you're an engineer. You're an air ventilation engineer. But I don't ask, well, what is he, what job is he applying for? Well, if they tell me afterwards, you're applying to be a brain surgeon, then my reference is not a good reference. I can only tell them what you're good at. And if I tell them that you'd be a good brain surgeon, then I'm not telling the truth, right? So it's the same thing here. If I say that so-and-so is good, I would lend him money, but and I'd leave it open-ended, then I would become a guarantor according to some opinions, because I didn't take the time to ask how much of this is this loan for,
Or, I mean, without knowing the
with
dollar.
without knowing a dollar amount. Yeah, so
So, I mean, that,
it could put you on the hook. You have to be careful with your language. If someone asks you a question, is this guy reliable? Is he good for a loan? The first question should be, well, how much are we talking about?
so I mean, the thing that we're talking about here in this previous one is based on the fact as to whether, like, it's been stated as to whether there's a dollar amount is stated, but really there's other parameters that could still be counted.
There are other parameters, right?
A guarantee without even knowing how
Yeah.
much money.
That's right.
When we had the
Let's
other
say
three-
let's say the guy is starting a business, but he has 3 partners. So I may trust the one guy that he's asking me about, but if I don't, but if I'm not told that he has 3 other partners, so then my reference was only for that person. It wasn't for the other 3 partners, and I shouldn't be on the hook.
You know, and going even further, you know, like I would say, so good, he wants to build a deck in his backyard, is he good to lend the money? Is he good to lend the money? And then you find out, instead of being a $10,000 deck, he gave him X, or he gave him $250,000. Like, what do you, no, no, but where are we drawing the line in terms of understanding of what the loan value is?
Right. Well,
You know,
if a guy,
like you said, he was good, so that means he's good for $100 billion, he's only good for $10,000. Like, you know, it's very vague, and it doesn't seem, that's what I don't think we stand up in court, like.
I think if a guy who wants to be a guarantor is careless in any way, and there's no misrepresentation, I think he's stuck.
I
Too
think,
bad,
exactly.
right?
well, that's
secular thing, secular.
That's the second opinion. The Rambam holds that you're not a guarantor until you know the amount. But the other opinions say that if you unconditionally guarantee a loan, then you've unconditionally guaranteed a loan.
Even if the amount is not stated, it's for something that you know it has to be in a realm of X amount of dollars, and all of a sudden it's 10 times that amount. For whatever reason, he came back, oh, by the way, I needed also to do my kitchen, and I had to do the second floor. And they didn't say, well, the guy said you know, you're good, so you're good for the whole, you're good, I'm good, I'm okay.
It's even worse for him, because there's actually a thing called a limited guarantee, where you actually, they stipulate that, yeah, there's a loan for 100,000, but I'm only, maybe in the Stamat stuff, my guarantee is limited to $3,000, and it says it. It says, I guarantee this loan to the extent
Up to
$3,000
Right,
Canadian, blah,
right.
blah, blah. That's it. If you don't say that it's limited, it's unlimited.
We had that
Right.
was earlier on, where the guy gave $100 and the loaner gave him $1,000, he was only up, the guarantor only had to pay back $100.
That's right.
Because that's what
That's
he said
right,
he was gonna pay,
correct.
which is your limit. But I
Mhm.
mean, to me, your language is so important when you're
Well,
talking.
that's the
about
whole
this.
thing. It's like, bro, if you let that, when you signed as a guarantor and it was, $1,000, let's say. And then the guy went back, the guy went back afterwards to the Gamach and said, listen, I need another 10. Is it okay? Because these guys are signed, of course they'd sign for the 10, as the 2, are you mechuyev to pay? No,
No, but usually with the Gamach, they state the amount always,
Yeah,
they state the amount.
it's there, but I'd have to go back and have a look at the, because I think it says that you take the whole amount as the guarantor, but they have 2 guarantors to make sure that somebody doesn't default. But I wonder if you were to write underneath that you would only guarantor 50% of that loan. Wonder if that would.
It's certainly upholdable. Sure. Sure.
Then if the loan will go through.
Well, exactly, then they might not get the loan.
Yeah.
Yeah. Okay, next. Mi shenit ratzeh lihiyot arev. Oh, before I finish, I'm going to be away from Monday through Wednesday of next week. So we'll meet next Thursday. Okay.
I'm away as well, that's correct.
So Monday through Wednesday of next week, I'm away, and maybe I'll put it in the
Put on the chat.
WhatsApp. Yeah.
Sure.
Okay. Okay.
Guaranteed 5 people are gonna show up. and say, Where's our
Yeah,
5?
there'll be a phone call. Do you know where the rabbi is?
All right. Mishin Isratza Lios Arev. V'kodem sheyitin hamal v'hakesef leloiva. Hischarei ta'arev. So a person agrees to be a guarantor. But then before the lender gives the money to the borrower, the creditor has a change of heart. Mechsha shehalo v'lo yachzir halva'aso bizman. V'yitztarachu l'shalim avura. I guess he's worried that maybe the guy won't pay back in time.
Maybe he should be updated.
No, he just went home and told his wife.
Yeah.
That's what happened, right? And she said, "You did what?"
Let's scratch that one.
So he has a change of heart. Hayim yachol lachzor mahaskamasu milios arev, o eni yachol lachzor. So can he withdraw his guarantorship or not? Kagon sha'asu kinyan. Im ha'arev al haskamasu lios arev alosu mamet. So the arev made a kinyan, right? He says, okay, I agree to be the guarantor in front of witnesses, makes a kinyan. Can he cancel his arevus, his guarantorship, since the money has not yet been handed over?
So is there a difference on money being transferred already, obviously, versus?
Once the money's been transferred, then for sure you're toast. Yeah,
So he signed the shtar.
yeah.
Now he wants
back at it.
He wants to back out.
The money hasn't transferred.
Money hasn't transferred yet.
Kickbacks.
So what are you saying, Mark?
It happens with banks too, where you fill out the loan application and get a mortgage and all that, and they approve it and all that stuff. There are cases where that goes to court to force the bank to give him the money. And the court, wearing its hat on equity, can compel you to keep your word. You've agreed to give something or whatever, the court can enforce that if there's consideration. So, yeah.
And can it work in the reverse? Can the bank cancel once they've given their guarantee that they're going to lend the money?
I don't think
And the
so.
market drops and all of a sudden the equity is not there in the house.
It's an agreement that's enforceable, we can set, then cost benefit, like, maybe you just go next door and borrow from somebody else, instead of that hassle. But I think there's an argument to be made, you could enforce that agreement to give the guarantee.
Okay, we will come back to this on Thursday.
So
It's a shame.
the borrower would be able to sue the guarantor for damage because he went ahead and did whatever he thought he was going to do with the loan.
Well, we don't know that. We don't know that yet. We don't
That's what
know.
I'm saying.
Okay, so could he? Okay, possibly. We'll see. All right.